Supplementary list fees case item 12, second appeal 118 of 2020.
I have framed two substantial questions of law. Further proceeding has been stayed till 10th of November. You have to take steps for issuance of notice. Comply the order. Order will be uploaded by the अंतर उसको 100 रुपये दे दीजिए.
Item 13, first appeal 233 of 2018.
इसमें आइए भाई.
आइए ऑलरेडी से बाहर फाइल वन आइए तो
आगे इसमें आगे आइए.
ठीक.
जब 4 weeks time. लास्ट आइए दिख रहा था रिकॉल वाला.
हाँ रिकॉल
वो था ही नहीं रिकॉर्ड पर.
हाँ on 26/8/2025.
Any reason which you have given? Show me.
I have shown my bona fides that several letters have been requests have been made by the deputy commissioner from the department, because there is provision for that account personal deposit which is operated by the DLO that has become that will become non-functional if the amount is not withdrawn within 2 years. उसको हम लोग अवधि विस्तार के लिए ये आपको ऑथराइज किया है, उसके लिए हम लोगों ने लिखा है और ये हो जाएगा.
इसको लिखा है तो बहुत दिन से चल रहा है.
तो इसका हमने लास्ट में भी हुजूर का भी आदेश का रेफरेंस देते हुए हमने लास्ट लेटर जो हम लोगों ने दिया है ये 29/8 का देयर इज रेफरेंस ऑफ द फर्स्ट अपील एंड
किसके पास भेजा आप? लेटर किसको लिखे हैं? Whom are you writing?
सब गया है सरकार के अपर सचिव राजस्व रेवेन्यू डिपार्टमेंट को.
Under secretary.
प्रतिनिधि फाइनेंस हो गया है. बोलो प्रतिनिधि फाइनेंस हो गया है. इसको नेक्स्ट
Secretary finance.
ये एड्रेस्ड है सब सरकार के अवर सचिव राजस्व निबंधन भूमि सुधार विभाग और कॉपी कम्युनिकेट फाइनेंस.
आपके पास वहाँ से कोई कम्युनिकेशन नहीं आया है?
हमें तो हमारे दिस इज नॉट बियॉन्ड रिकॉर्ड. आई एम सेइंग कि हमने टेलीफोनिकली हमने पूछा तो बोल रहे थे कि नहीं हो जाएगा. हाँ जैसा आपने टेलीफोनिकली दैट इज नॉट ऑन रिकॉर्ड.
आई विल नॉट रिकॉर्ड इट.
हाँ ये
कि आई नंबर 12417 of 2025. A petition has been filed seeking extension of 4 weeks time to comply the order dated 26/8/2025. The Learned Counsel for the state has submitted that as per the norms, once the amount is not withdrawn from treasury in the matter of land acquisition proceedings, the account becomes
non-functional.
The क्या नाम है जो आए हैं?
DLO राम नारायण खलखो.
Mr. Ram Narayan Khalko, who is present in the court and is the district land acquisition officer Dhanbad, has stated in this affidavit that appropriate steps have been taken by giving the reference of the order dated 26/8/2025 also, that the amount is that necessary steps are to be taken so that the amount be deposited before the executing court. We have submitted that last such letter has been issued on 29/8/2025, and prior to that also numerous letters were issued.
Yes.
The Learned Counsel representing the state has submitted that extension be granted
or authorization
or for the required authorization, and 4 weeks time would be sufficient. Considering the aforesaid submissions and the interlocutory application, the time to comply the order dated 26/8/2025 is extended till 7th of October. हो जाएगा 7th October.
और थोड़ा सब्जेक्ट ऑलरेडी
अभी दुर्गा पूजा तो नहीं मनाएगा आदमी, लेकिन
उसको दुर्गा पूजा के बाद ही रखा जाए। हमने अंडरटेकिंग भी दिया, हमने क्लियर भी लिखा, हमने डॉक्यूमेंट्स भी लगाया है। फिर बोनाफाइड आई एम शोइंग माय बोनाफाइड्स।
ठीक, बोनाफाइड आप दिखाए, अच्छी बात है। 7 ठीक है, आपने 4 हफ्ता टाइम मंगाया तो हम 5 हफ्ता कर देंगे।
ठीक है।
ठीक है। Post this case on 9th October. The affidavit should be filed. Latest affidavit after depositing the amount before the executing court should be filed latest by 8th of October. हो जाएगा?
हाँ। Personal appearance of the DA. At present.
Billing which खाली कर दिया जाए कि नहीं होगा।
At present.
Sorry.
If the amount is not deposited, then the billing which he should again appear. Then he should.
The personal appearance of
DLO.
we are not interested in personal appearances. He has been asked to remain
हाँ,
personally
yes.
present.
Earlier there was order.
The concerned officer need not remain present in the court if the order dated
9/6 there was.
if the order dated 26/8/2025 is complied, an appropriate affidavit is filed in terms of this order. हाँ, आइए। जमा होने के बाद फिर ना हम लोग हियरिंग करेंगे तुरंत।
हम तो आज भी रेडी, हम तो हमारा डेट में रेडी होके आ
खाली जमा होने दीजिए। और क्योंकि ऐसे जब इतना दिन लेट हुआ है तो डिसबर्सल ऐसे नहीं होगा।
हम इसमें
एग्जीक्यूटिंग कोर्ट के पास जरूर रहेगा,
लेकिन
लेकिन
भी नहीं किए,
डिसबर्सल का कोई बात
ऑब्जेक्शन कुछ भी नहीं किए।
बस पैसा आ जाएगा तो कम से कम ऑर्डर होने के बाद जिसको भी पैसा मिलना होगा मिल जाएगा।
उसमें कोई दिक्कत नहीं है।
Autoton mention case from daily list item 16, first of 62 of 2025.
Four defendants were there. Personal notices and he is appearing on ground.
Okay, you have already appeared. You are seeking interim relief, right? Disturbing the position. कब करेंगे बताइए?
I have already filed the अच्छा date.
हाँ, date
Any day on in the next week, madam.
रिकॉर्ड आ गया इसका? क्या मैटर है?
Matter is that I am claiming that in 1921 the person who was recorded in CS Khatian, they by registered deed transferred the property to my predecessor in interest, and thereafter by another deed it has been transferred to me. And they also, the person after it was transferred in 1921, the same descendant of the same recorded tenant in 1958, he transfers it in 1958. That is the.
तो आपका subsequent deed है।
हाँ.
ट्रायल कोर्ट क्या कर दिया?
Trial court dismisses my suit. I have.
On what ground? You have a prior title deed
Yes.
by the same vendor.
Yes.
With respect to the same
Yes.
property. Then why did the
So
trial
because
court
your
dismiss?
lordship, because they had their name was mutated in the year 1986 and all other ground, the trial court
On
dismissed.
ground of mutation.
Mutation. So it is only a case of competing deeds as to who would have. If my deed is prior in point of time, then I have title. So therefore I was saying that otherwise the matter would be short, but I will not insist on any date of hearing. Whatever is convenient to your lordship, your lordship.
बहुत अजीब नहीं है? Subsequent deed को क्या बोल के?
No, your lordship, I don't want to comment on the orders passed by some of the officers, but this is the difficulty we face.
IA number 12353 of 25 in FA number 62 of 25 has been filed with a prayer that appropriate order be passed restraining the respondents from disturbing the possession of the appellant over the suit property. म्यूटेशन इनके नाम से हुआ, पोजेशन आपके पास है?
हाँ, पोजीशन तो मेरे पास है.
1986 म्यूटेशन हमारे नाम से ही respond
पोजेशन में क्या फाइंडिंग है?
Actually, what would happen, Your Lordship, all these persons, they were residing in outside in West Bengal. So, whatever transfer was there, it was absolutely vacant land. So, if it is a vacant land, the person who has the title would be deemed to be in possession.
The learned counsel for the respondents has submitted that the records have already been received. Instead of passing any order in the interlocutory application, the case be finally heard. With the consent of the counsel for the parties, in view of the aforesaid circumstances, this court, instead of passing any order on the interlocutory application, fixes the final date of hearing in this case on 7th October.
Whatever.
7th October? Right. In the supplementary cause list,
Yes.
under the heading for final disposal. आइए close.
From date is for hearing under order 41 to 11 item 18, second April 67 of 2019.
IA number 12301 of 2025 has been filed for substituting the name and legal name of the respondent number 4, who died on 2/6/2025. Mention, kindly see para 4.6.
IA number 12301 of 2025 in SC number 67 of 2019 has been filed seeking substitution of deceased respondent number 4, namely Kaleshwar Mehto, who said to have expired on 2/6/2025. The counsel for the appellant has submitted that the name of legal heirs and successors of respondent number 4 has been mentioned in paragraph 4 of the interlocutory application. Let notice be issued to the proposed legal heirs and successors of respondent number 4 through speed post and also through ordinary process.
Kindly order in ordinary basis. Because
Speed post से हम लोग का सर्विस जल्दी कंप्लीट होगा. Through speed post and also through ordinary process. In IA number 1 in the posted interlocutory application, the requisites be filed by within 10 days. Post on 10th November. Arrangement service.
Item 19, second April 68 of 2019.
Limitation is pending. Limitation is pending. सब क्या लिखेंगे? कोई आगे pending है इनका?
नहीं.
और service is complete. Service is complete.
I'm waiting for the respondents. Clear हो गया?
हाँ.
On behalf of respond number, all the respondents.
कुछ स्टेट कुछ करके ये लोग तो बता रहे हैं 1, 2, 3 and 4.
You are
The substituted plaintiffs.
respond number 1 to 4, right?
Yes, sir.
1 to 20 को लिमिटेशन के लिए नोटिस हुआ था 19/4/23. Delay has been condoned. सर बिना डिले किए कंडोन किए हुए आपका कोई ऑर्डर कर देंगे तो गलत हो जाएगा ना?
Milord.
हाँ बताइए, कोई आगे पेंडिंग है? डिले कब कंडोन हुआ? अच्छा आगे
13/8/24 का एक ऑर्डर है
हाँ
मिलॉर्ड,
ठीक.
इसमें लिखा हुआ है कि लिमिटेशन पिटीशन अलाउड.
आप बड़ी क्या है आपका सब्सटेंशियल क्वेश्चन?
Milord, it's a case where the daughters claiming Milord partition, scheduled tribe daughters, claiming partition, Milord, from the India
Which
ancestors.
community? Which community?
Santhal, Milord. Santhal. Now the point for your lordship's Lord consideration is the trial court has given finding that these plaintiffs, Santhals, now they are practicing Hindu custom and all. This is what the trial court said, but no issue was. Now this is something very important for your lordship's consideration. But trial court did not frame any issue as regards the adoption of Hinduism. इस पर कोई issue नहीं frame हुआ था, and which was the main issue and vital issue in the suit. Number one. Now the trial court gave a finding, and finding on no specific evidence की locality में किस के यहाँ से इस पर कोई evidence नहीं आया. हमारा हुजूर से यह अर्ज होगा कि I will draw your lordship's kind attention to section 2, subsection 2 of the Hindu Succession Act, Lord, for your lordship's kind consideration, and then I will frame the substantial question of law for your lordship's consideration, Lord. Because scheduled tribe, they can't claim to be, following the Hindu laws, because that is barred under section 2(2), Lord, of the Hindu Succession Act. Unless the central government, by notification, de-notify them as scheduled tribe. This is what, Lord.
No, but Hinduized tribals are also there. There are judgments which says that if they are sufficiently Hinduized, then under such circumstances they will be guided by Hindu law.
एक दो इंस्टांस खाली बोल देने से kindly Lord consider section 2(2) Lord of the Hindu Succession
We are
Act.
aware that tribal laws, Hindu law is not applicable on tribals, on
No.
customary law.
Unless Lord it is said Just my lord.
Where is the, you are the defendant, right?
We are the defendants,
Where is
Lord.
the case of the defendant?
We are the defendant
Where is the
agnates.
case of the defendant?
We are the
What was
agnates.
your
Lord.
stand in the by the defendant?
My lord, stand was
You read
specific
it, please.
that no
You
Hinduism.
read it, please. Defendant number 1. The defendant number 1 only filed a written statement, and the others they did not file the written statement, and they were debarred from filing a written statement. Who is defendant number 1?
This contesting the.
No, he is contesting. What is the relationship of defendant number 1?
My lord, relationship is, my lord, we are from brother side.
It was earlier suit between two brothers. Subsequently, the plaintiff, one of the brother has died. Therefore, they have been substituted. They have the substituted.
And who had no son, and the daughters not.
The daughter steps into the shoes of one of the brother who is their father-in-law. So initially there was no question of Hinduized because संथाल में भी तो partition होगा among two brothers.
नहीं ठीक है तो ब्रदर के बाद ब्रदर का जब डेथ हो गया जो प्लेंटिफ था मिलॉर्ड हम लोगों का ब्रदर ही था जो प्लेंटिफ था उसके डेथ के बाद ही हैज नो सन एंड द डॉटर्स हैव बीन मिलॉर्ड सब्स्टिट्यूटेड सो नाउ द क्लेम फॉर पार्टीशन इज फॉर द डॉटर्स इन द सूट नाउ दिस इज द पोजीशन सो क्वेश्चन इज whether the findings that they have become Hindus or by practice, this is not based on cogent, consistent evidence. Simply, the plaint will also show. The 3 paragraphs I will read. प्लेंट में भी कहीं कुछ नहीं है कि किस किस फैमिली में और हम लोगों के यहाँ भी कौन क्या क्या हिंदू प्रैक्टिसेस कर रहे हैं ये सब कहीं प्लेंट में भी नहीं है भाई सो नो प्लीडिंग एंड देन नो एविडेंस ऑल्सो ऑन दैट पॉइंट एंड देयरफॉर द फाइंडिंग्स अराइव्ड एट मिलॉर्ड बाय द courts, both the courts, Lord, that is based on no proper pleading, no sufficient pleading, and no sufficient evidence, which is a very serious, Lord, finding in a case where Santhal tribe, where Lord section 2, subsection 2 says, Lord, if your Lordship permits me, Lord, I will just read. क्योंकि उसमें साफ है कि हिंदू लॉ विल नॉट अप्लाई टू देम अनलेस द सेंट्रल गवर्नमेंट बाय नोटिफिकेशन दिस इज द लाइन
सर वो आप ये तो ठीक है स्टैट्यूट तो पढ़ रहे हैं वो हिंदुआइज ट्राइब का जजमेंट कहाँ The tribes which are sufficiently Hinduized are to be governed by Hindu law. Where is that judgment?
लाभेश्वर माझी 2000
लोकेट नहीं कर पाए लेकिन हम खोज रहे थे
लोकेट आप इतना संथाल प्रगना का केस करते हैं आप बोलते हैं कि आप लोकेट नहीं कर पाए ये मानी नहीं सकते हम दिन रात आप वहीं का
वो
केस
जजमेंट
करते
भी
हैं
हम लोग निकाल के एक बार देख के
क्या
इसको
देखना है उसमें
that judgment it is said is quoted in the appellate judgment of the impugned hearing. Prem Maji versus Labeswar Maji versus Pran Maji, page 21, running page. और हमारा प्लेंट में स्पेसिफिक है जो हम बोले हैं
कहीं कुछ एग्जाम्पल वगैरह कुछ नहीं है कस्टम एडॉप्शन का प्रूफ बहुत सफिशिएंट प्रूफ आने चाहिए उसके
हाँ बोले हैं प्लेंट में और हमारा एविडेंस में भी आया है
because claiming inheritance which is barred under the Santhal law of the daughters.
then कुछ नहीं है, evidence भी आया है, parties have joined issues on this. Essay number 68 of 2019. Counsel for the appellant is present. This appeal has been filed against the judgment dated 10/8/2018 within bracket. Decree signed on 20/8/2018 bracket close. Passed by learned Principal District Judge Jamtara in Civil Appeal number 11 of 2018, confirming the judgment dated 5/1/2018 within bracket decree dated 19/1/2018 bracket close, passed by learned Civil Judge within bracket Senior Division 1 bracket close Jamtara, entitled within bracket partition suit number 27 of 2011. The learned counsel for the appellant has submitted that initially partition suit was filed between two brothers.
Yes.
Two brothers. However, on account of death of the plaintiff, his widow and daughters were substituted. The defendant had also expired and he was also substituted. लग रहा है बहुत सारे पार्टी हैं.
Mansingh Marandi is the appellant here.
Sorry,
Mansingh Marandi is the appellant here. Therefore, one of the defendants. That
he is only one. There were numerous defendants.
मानसिंह वो मेन ब्रदर है, वही डिपेंडेंट मेन है,
अच्छा.
मानसिंह भी आपने
सब्स्टिट्यूशन हुआ है क्या डिपेंडेंट्स का?
नहीं हुआ इसमें, ऐसा तो कहीं डिग्री में, ट्रायल कोर्ट का डिग्री में कहीं नहीं हुआ, डिलीटेड और सब्स्टिट्यूटेड.
ऐसे लिखिए. He has submitted that the suit was filed by Munshi Marandi.
फ्रॉम द प्लेंट आई फाइंड लॉर्ड डिपेंडेंट नंबर 1 वही मानसिंह मरंडी का जो भाई है उसका,
और बाकी लोग
एंड और भी लोग हैं,
अच्छा ठीक है.
सेवरल.
ठीक है. भाई राशि Marandi against his primarily against his brother, seeking partition of the suit property, and he claimed a preliminary decree of 1/4 share in the suit property. However, during the pendency of the suit, the plaintiff had expired and he was substituted by his widow and 3 daughters. The plaintiff did not have any son. Correct? The learned counsel has submitted that the parties belong to Santhal community, and as per customary law of Santhals, the daughters / widow are not entitled for any share in the ancestral property. He has submitted that in spite of this fact, the learned court has decreed the suit and found that the plaintiffs were entitled to get 1/4 share of the suit properties.
The trial court did not frame this issue.
The learned counsel submits that the decree was passed primarily on the ground that the parties were sufficiently Hinduized but no such issue was framed by the learned trial court. And accordingly, the finding of the learned trial court that the parties were sufficiently Hinduized was beyond the frame of the suit. The parties belonging to Santhal community, the Santhal tribe, are guided by customary law of Santals, and in view of section 2 within bracket 2 of Hindu Succession Act, the 1956, the provision of the said act does not apply to members of any scheduled tribe within the meaning of clause 25 of article 366 of the Constitution of India unless the central government by notification in the official gazette otherwise directs. The learned counsel submits that no notification as such has been issued by the central government to include Santhal tribe to be governed by Hindu Succession Act, and accordingly no such notification was exhibited before the learned courts, and therefore the parties are governed by customary law applicable to Santhals, and therefore allocation of any share of the suit property to the widow and 3 daughters of Santhal is not in accordance with. The learned counsel submits that this aspect of the matter has also not been properly considered by the learned first appellate court. After hearing the learned counsel for the appellant, this court finds that it is not in dispute from the side of the learned counsel for the appellant that the original plaintiff was Rushi Marandi, and he had filed a suit seeking partition to the extent of 1/4 share of the suit property. However, he expired during the pendency of the suit and was substituted by his widow and 3 daughters. The specific case of the original plaintiff was that except pro forma defendant, the parties are Santhal by caste. But with the passage of time, both the parties have adopted Hindu laws and customs, and in this way they have become Hinduized. It was also the case of the plaintiff that the land of AKJ क्या होता है?
एक्सट्रैक्ट खतियान जमाबंदी.
वही जमाबंदी.
The land relating to Jamabandi number 25 of Moza Randhamat was recorded in the name of Badinath Marandi and others in the last survey settlement. These plots were mentioned in Schedule A and was recorded in separate Dakhal Pyari of Badinath Marandi and Samai Marandi. And some of the plots within Khata number 25 were recorded in the name of Badinath Marandi. And Bariyar Marandi and Shobha Marandi, and these lands were mentioned in Schedule A by 1. In Schedule A by 2, two tanks were mentioned, which were jointly recorded in the name of Badnath Marandi, Somai Marandi, and Shobha Marandi. The land in connection with Jamabandi number 72 of Mauza Jamjuri was mentioned in Schedule B of the plaint and was also recorded in the name of Badnath Marandi and Somai Marandi. There was another schedule, that is Schedule C, with respect to trees, bamboo, clumps, and ancient houses and plants. The genealogical table was also provided in the plaint, and it was asserted that and it was recorded that the original plaintiff Bunshi Marandi was represented through his legal heirs and was son of Samai Marandi, and dependent number 1 Man Singh was son of Samai Marandi and own brother of Bunshi Marandi. The entire genealogical table was stated, and it was and cause of action arose when the plaintiff came to know that defendant number 1 had started dominating the family and tried to misappropriate some joint family properties. The defendant number 1 filed his written statement, but so far as other defendants are concerned, they did not file their written statement, and by order dated 7/3/2013, defendant number 2 to 18 were debarred from filing their written statement. The specific case of the defendant number 1 was that the suit was not maintainable, and he had admitted that the parties are Santhal by caste, where it was denied that they are not governed by the learned trial court also recorded that the learned trial court also recorded that the fact of becoming Hinduized of both the parties was disputed. However, the learned trial court framed the following issues for consideration. And after having recorded that by deciding issue number 3 with respect to as to whether there is unity of title and possession between the parties over the suit land, and as to whether the plaintiffs are entitled for any relief as claimed, the learned trial court took note of the fact that the factum of becoming Hinduized by both the parties was a disputed fact, and so it was to be decided on the basis of the materials available on record, particularly the evidence of the oral witnesses who have been examined on behalf of the defendants. The learned trial court recorded that defendant number 1, Man Singh, who was examined as DW1 in para 18 of his cross-examination, had stated that at the time of marriage, Varmi is put, and in case of death of husband, it is washed. Similarly, other witnesses were also cross-examined, having accepted the fact that they have adopted Hindu customs. The learned trial court came to a finding that from the evidence of the witnesses examined on behalf of the defendant number 1, it was clear that both the parties are Santals by caste and they are guided by Hindu customary law, and the moment it is proved and established that the parties are guided by Hindu customary law, Hindu law partition will be happening. Thereafter, the learned court proceeded to partition the property amongst the parties and allocated 1/4 share to the plaintiffs. So far as the learned first appellate court is concerned, the learned court framed the following issues for adjudication, following points for adjudication at paragraph number 8. Number 1 है whether the plaintiffs / respondents are Hinduized Santals or not. Roman 2, are the plaintiffs respondents are entitled for their share in the suit property or not. The learned first appellate court also scrutinized the materials on record and came to a finding that the Santhal female cannot inherit her father's property and provision of Hindu Succession Act will not apply to her, but a Santhal female will certainly inherit father's property if they have adopted Hindu customs and have converted themselves into Hinduized Santhals, and thereafter proceeded to decide the point for determination. The learned first appellate court referred to the judgment passed by the Honorable Supreme Court in the case of Lavisher Manji versus Pran Manji and others, reported in 2001 within bracket 1 case JCR 42 within bracket SC, and observed that it has been held that the female excluded from right of succession, and if evidence is there on record that parties are Hinduized Santals adopting name, custom and tradition of Hindus, the provision of Hindu Succession Act will not apply to exclude the parties from application of Hindu Succession Act. The learned court ultimately held that there was enough evidence in support of the fact that the parties have adopted Hindu customs and they are Hinduized Santhals, and held that the parties could not be excluded from the application of Hindu Succession Act, and ultimately was of the view that the learned trial court has not committed any illegality or irregularity in by passing the judgment. This court finds that although the learned trial court has not framed a separate issue as to whether the parties were sufficiently Hinduized, but the parties had joined issue in their evidences and arguments on the point as to whether they were sufficiently Hinduized or not. And ultimately, the trial court came to a finding that the parties were sufficiently Hinduized in order to apply the provisions of Hindu Succession Act. The learned First Appellate Court specifically framed the point of determination as to whether the plaintiffs were Hinduized Santhals or not, and after scrutinized the materials found that the parties were Hinduized Santhals, and by applying the judgment of the Honorable Supreme Court in the case of Labishwar Manjhi Supra, was of the view that the parties could not be excluded from the application of provisions of Hindu Succession Act. This court finds that both the learned courts have considered the materials on record and case of the respective parties and came to finding, so far as appreciation of materials on record is concerned, no perversity as such has been pointed out by the learned counsel for the appellant. This court is of the view that both the courts have passed appropriate judgments based on materials on record, and no substantial question of law is involved in this appeal, which is hereby dismissed.
My presence may also be important.
Not the point. Go up.
Item 20, second to 73 of 2019.
What is the matter? What was the suit for?
Declaration of title. By fraudulent
Suit was decreed.
decreed in my
An appeal?
appeal partially. The appellate court has reversed the schedule A, schedule B property, schedule A has been interfered. That was because some imposter by fraudulently deed of partition was prepared by the.
When do you want to do this? कब करना है?
After
कल परसों परसों
पूजा
कौन सा पूजा? 2019 का केस में अभी तक सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं बना। करेक्ट? There is no reason to grant such long time.
23rd
Essay number 73 of 2019. पिछली बार आपको कॉस्ट दे दे के आपका एडजस्टमेंट हुआ था, है ना? 1000 रुपये कॉस्ट आप दे चुके हैं पहले. The learned counsel for the applicant has submitted that he has circulated advance notice seeking adjournment. आप ही का आया था ना इसमें? He submits that the matter be posted on 23rd of September. Considering the submissions, let this matter be posted on 23rd of September. No further adjournment will be granted.
Item 21, second appeal 79 of 2019.
What was the suit for?
Lordship, the suit for eviction was filed by the Railways Lordship, and that was dismissed. Considering Lordship, the earlier judgment, one judgment was passed in the year 1996. In that case, Lordship, that was decided in my favor, and the plaintiff Lordship in that case was said to be a lessee, not a licensee. And since Lordship, no appeal was preferred by the union, and therefore the trial court came to a finding that he was a lessee, not a licensee. Therefore, a proper suit under TP Act should have been filed, and that was not done. Now, Lordship, I have framed some substantial question of law.
No, I just want to know. The trial court ultimately held that you are in the earlier suit.
I am a lessee.
You are a lessee.
Lessee.
So therefore, for eviction, Transfer of Property Act 106, 107.
Yes.
Okay. No suit was filed by Railways thereafter.
No suit.
They filed another suit.
Another suit. No appeal was preferred against that.
That's it. No appeal was preferred.
This suit was filed, Lordship. Again, Lordship, the same contention was taken.
By saying that you are a licensee.
Licensee. And therefore, Lordship, it was said to be barred by res judicata. And now in the appeal, Lordship, there were 4 plots. Total 4 plots were there. 20, 21, 11 and 12. For 2 plots, Lordship, in the appeal, appellate court said that since it was decided only for 2 plots, and therefore for the rest of the 2 plots, it was not decided. Therefore, you will only get benefit for half of the plots.
Certainly.
No, that is what the judgment is, Lordship.
No,
but since
see, when the identity of the property is not the same in both.
That is my substantial question. Since the entire judgment, which is Exhibit 7, has not been properly constituted, and secondly, Lordship, the
where is the
appellate court,
judgment?
Exhibit 7. It
Was
is
it
exhibit.
in relation to?
Yes,
only
the
2
entire
plots?
things are there. Since
No, entire. What was the suit property in that case?
all the 4 plots.
All the 4 plots?
Yes, therefore I am saying the trial court, the
How did the
appellate,
judgment?
इसमें हुजूर नहीं है. The trial एक मिनट जरा बता दें. सुन लिया जाए. Lordship will come to find it. The appellate court have also decided that all the issues has been decided in favor of the plaintiff, in favor of the defendant, against the plaintiff in the trial court is proper and correct, but only 2 other issues to be seen whether this is barred by res judicata or not. That has only come. I'll come to the 4 issues, Lordship, first. What were the 4 issues which is held to be decided against the plaintiff by the trial court, which has also been accepted by the appellate court? I'm just coming to those 4 issues. That will clear the entire matter.
The entire argument revolves around res judicata according to you.
No. Many things are there, Lordship. Since they have terminated our license, the lease was given, the rents were accepted. Entire many things are there, Lordship. All things have to be properly considered, and then only, Lordship, the decision could have come. And now he is accepting 7, 5, 6 issues. Only 2 issues, only that is for the collateral purpose. Only that issue was decided by the appellate court against the defendant, and therefore, Lordship, the suit for those 2 portions have been decided. May I place, Lordship, the issues which was framed? That is at page, internal page 6, Lordship, of the trial court judgment, at page 48. Five, 6, 7, 8, Lordship, these 4 issues. These 4 issues were said to be decided by the trial court in my favor and also accepted by the appellate court. That is first issue, Lordship, with regard to the same all these properties. Whether the judgment and degree passed in title suit number itna with respect to suit number plot number 11, 12, 20 and 21 of Manoharpur railway premises operates as res judicata in present suit. And this is decided, if we are taking only this, Lordship, this is decided by trial court as yes, appellate court as no. Now, Lordship, 6, 7 and 8, 9. What is all this? Whether the plaintiff has terminated the license lease of defendant in accordance with the provisions of the Transfer of Property Act. This is the most important issue. And both the courts have decided this issue in my favor. Even assuming that those two plots were not there, even assuming for the purpose of our argument. But this was not decided. The Transfer of Property Act, the recourse of the Transfer of Property Act was not taken. That was my contention.
What is the finding with respect to issue number 6?
Yes, Lordship. Go ahead.
By the learned first appellate court.
Yes, I am coming to the first appellate court itself. Very small judgment is there. 3 lines is there, just it seems. ये जो फाइंडिंग में आएगा
पहले 18 से पढ़िए
हाँ बस 16 में दिया 14 and 16 is important इसमें इशू नंबर 6 जो मिलेगा that's what whether the issue number 1 2 4 1 2 6 7 and 8 decided the learned trial court is sustainable in the eye of law as well as the facts. The learned court below has properly and correctly decided the above issues and arrived at right conclusions, which calling no interference. This is what the 3 line things are.
So you are harping on issue number 6 over.
Yes, that is the most important issue. And my substantial question of law should have framed. That is first lordship A and E. D also, lordship, D is also important since exhibit 7 is my simply, lordship, the appellate court has accepted the version of the trial.
What is the substantial question of law?
At page 5, lordship. Starts from page 5. First of all, lordship, I'll harp on A and B also, lordship, because these 2 main issues are there.
Demand का कहानी नहीं सुना
लॉर्डशिप
A नहीं बनाएंगे
A बन B बना सकती हैं और D बना सकती हैं.
What is exhibit 7?
That is the earlier suit which was decided
ये कैसे
1996.
पता चलेगा?
हाँ?
ये तो आपको ये तो ऐसे हवा में तो नहीं बना सकते
नहीं,
दिखाइए exhibit 7 हमको
अगर देखते हैं उसमें हाँ
नहीं है तो नहीं बनाएंगे ना ऐसे तो नहीं बना सकते Can't be like this.
B और E उजूर बना सकते हैं. E and B are more or less they are same because I don't have that judgment.
You heard the learned counsel for the appellant. This appeal, the learned counsel for the appellant has submitted that there are concurrent findings. The trial court decided issue number 6 in favor of the
Against the plaintiff.
against the plaintiff. And the issue number 6 was as to whether the plaintiff had terminated the license/lease of defendant in accordance with the provision of Transfer of Property Act. Still, the suit was partly decreed. The suit was partly decreed.
The suit was dismissed
The suit was dismissed,
and the appellate court
but the
partly.
appellate court has partly decreed the suit. The learned counsel has also submitted that while partly decreeing the suit, the learned first appellate court was of the view that the plot number was of the view that the defendant was not to be Is there any finding that you were a licensee?
Let's see.
Lessee?
हाँ
Where is that finding?
वो तो ट्रायल
Finding दिखाई दे।
ट्रायल कोर्ट में अपलेट कोर्ट तो कुछ लिखा ही नहीं।
Trial court का finding।
Right.
Just a moment. बताइए सर।
पैराग्राफ 14।
Paragraph 14 is I would consider.
Not sure. Now I will proceed to consider the contention of both the sides having regard to and documentary evidence led by both the parties. As regards the issue regarding the termination of lease license, issue number 6, I find that the plaintiff tried to project that by Exhibit 4, license of the defendant was cancelled, and BW1 tried to show that the plaintiff did not accept rent and not renew the license of the defendant for a period of such and such. Having regard to the stand of the plaintiff, I find that this court has already held that the principle of res judicata in regard to the suit land apparent in the plot number 12 and 21 as applicable by Exhibit 7. The defendant has already been held lessee of the plaintiff, which can be terminated only on the basis of transfer of property act. As the plaintiff by Exhibit 4 has shown to have been terminated license and lease of the defendant. As such, the court is of the view that Exhibit 4 is bad in law as regard to suit number such and such. Similarly, with regard to the not renewal of the lease license for the non-acceptance of rent, I find that this stand cannot survive in respect of the suit land according to plot number such and such, as a defendant has been held to be lessee and not licensee by Exhibit 7. That Exhibit 7 is the judgment of the stand.
No, that is the Exhibit 7 with respect to two properties.
नहीं उसमें पूरा आगे लाइन पढ़ा जाए हुजूर. I find that this stand cannot survive in respect of the suit land.
में ट्रायल appellate court तो दो land को exclude कर दिया ना?
हाँ exclude किया तो ट्रायल कोर्ट चारों के बारे में बोला.
Where is the license document?
Licensed document.
What is that exhibit?
Yes, sure. Just giving the exhibit number. Office copy Exhibit 1. Office copy of license. That is at page 7, Lordship. Internal page 7, running page 49. Para 8.
The learned first appellate court, although affirming the finding with respect to issue number 6, still partly allowed the appeal and partly decreed the suit. Considering the submission, this appeal is admitted for final hearing on the following substantial question of law B. ठीक है? B and C दोनों ले लीजिए. C भी ले लेते.
हाँ.
Issue notice to the respondent. Where is the respondent? Union of India. ये यूनियन ऑफ इंडिया को कैसे हम लोग सर्व करेंगे? कहाँ एड्रेस होगा? कहाँ नोटिस देंगे आप?
ईस्टर्न रेलवे लॉर्डशिप दिया हुआ एड्रेस बाय इट्स जनरल मैनेजर.
अच्छा. है कोई यूनियन ऑफ इंडिया के एडवोकेट यहाँ पर?
कॉपी भी सर्व कर सकते हैं, लेकिन बट एक बार नोटिस जाना चाहिए, अदरवाइज दे अलॉट द ब्रीफ इन सिविल साइड.
Now issue notice to the respondent through speed post for which requisites be filed within a period of 1 week. Office to track speed post delivery. Let the records be called for from the concerned court. Post this case on 7th of October.
7th
October.
for opening day.
एक दिन के बाद.
कुछ और कर दिया
छुट्टी के 2 दिन
for
पहले
14 कर
छुट्टी के 2 दिन पहले छुट्टी खत्म हो जाती है.
14 कर दीजिए.
9th को कर दीजिए. 9th.
Item 22, second bill 249 of 2020.
The plaintiff or the defendant?
Defendants. Defendant second appeal lost from both the courts.
Which is the matter?
Plaintiff instituted the suit for cancellation of the registered power of attorney executed in favor of defendant number 1, and on that basis defendant number 1 executed a settlement in favor of defendant number 2. So C instituted the suit for cancellation of both the registered power of attorney as well as the settlement. During the suit, C never appeared before the court to depose that C never executed the registered power of attorney. Her son appeared stating that he has received power of attorney to depose on her behalf, which could not have been permitted. He could have been a witness on behalf of the plaintiff, but he could not have deposed.
You are the purchaser of the property.
One is the power of attorney holder and 2 is the purchaser. Both the learned
Substantial question of law बताइए. कहाँ बनाएं?
It's supplementary writing. First one is, if the Lordship may kindly see, substantial question law number 5. Page 4.
Roman 4 तक ही.
Supplementary to 1, 3 and 4. I am relying on it. इसमें one more aspect is there. Although it was not an issue before the court, neither the case of any of the parties not in the pleading, defendant number 1 stated his age to be 20 years. But during cross-examination, he was asked a question as to what was his date of birth. He stated his date of birth to be of 1994. So the learned, both the courts below come to a finding, and since he was a minor, he could not have entered into an agreement, and so registered power of attorney executed in his favor was null and void. So on both these 2 points, the registered power of attorney as well as registered sale of data. So I am relying upon 2 things. Firstly, it was not neither the case of any of the parties, nor it was the issue, nor any evidence could have been considered, because in the chief he says 20 years, in cross examination he says that year of birth is of 1994. So on that basis, this issue could not have been decided.
Year of birth of the person in whose favor the
Power of attorney was executed.
And that particular person in whose favor the power of attorney was executed was never examined.
No, he was a defendant. He was also made a defendant. Then the second question, if his minority was decided, then a suit was not maintainable in the first instance as against a minor, without complying with provision of section order 32 of CPC. appointment of a guardian by the court and
He
then.
was a minor at the time of filing the suit also.
No. We are saying that he was a minor. He was a major because suit was instituted as against him, but considering his age to be more than 18 years of age.
That's right.
Court considered it to be a case, and court, without framing any issue, without any pleading, held that defendant number 1 was a minor at the time of execution of the case.
At the time of execution.
Execution.
But at the time of suit.
At the point of suit also he was minor, if that age is taken into consideration. Because power of attorney is of
इतना
the.
लंबा सेंटेंस में आप सब्सटेंशियल क्वेश्चन ऑफ लॉ बनाएंगे तो कैसे?
मेमो ऑफ अपील का सब्सटेंशियल क्वेश्चन नंबर 5 है.
इसी से क्या हो जाएगा? She denied to have executed the power of attorney.
In the plaint, but she never appeared before.
That's right, in the plaint.
In the plaint, she denied.
And power of attorney was in favor of the
Defendant number 1.
defendant number 1.
And thereafter, defendant number 1 executed a salary in favor of defendant number 2.
Essay number
240.
249 of 2020. The learned counsel for the appellant has submitted that the power of attorney was executed by original plaintiff in favor of defendant number 1, and it was asserted in the plaint that she had never executed the power of attorney, and consequently the power of attorney as well as the sale deed executed by defendant number 1
In favor of defendant
in
number
favor of defendant number
2.
defendant number 2 were challenged in the suit. The learned counsel submits that the original plaintiff who had executed the power of attorney never appeared before the court, and rather the defendant number 1 who was authorized to
PW1, son of plaintiff.
but rather the son of the plaintiff appeared to adduce evidence on behalf of the original plaintiff by obtaining a power of attorney.
Power.
The learned counsel submits that it was never the case of the plaintiff in the suit that defendant number 1 was minor at any point of time, and therefore neither any such issue was framed nor the parties joined any issue on this aspect of the matter. He submits that in spite of this, the learned courts have held that the defendant number 1 was minor at the time of execution of the power of attorney by the original plaintiff, and therefore the power of attorney as well as the sale deed executed pursuant thereto were null and void. The learned counsel submits that the courts have gone beyond the frame of the suit, which has highly prejudiced the defendants. You are the sole appellant?
No, 2 applicants.
All the defendants are the appellants?
Two respondents are there.
Pro forma.
No,
All
both
the
are the
defendants,
sons.
all the defendants are the appellants?
All the defendants are there.
The learned counsel submits that all the defendants are the appellants before the suit. After hearing the appellant, this appeal is admitted for final hearing on following substantial question of law. Roman 5, मेन पिटीशन का रोमन 5, इंटरनल पेज 4, ध्यान देंगे कहाँ से क्या कोट करते हैं. और ये माइनॉरिटी वाला कहाँ पे लिखें?
सप्लीमेंट्री एफिडेविट में पेज 3 में 3 and 4.
पैरा 3 and 4. ये सप्लीमेंट्री एफिडेविट है, ठीक है? ये वाला जो आप बनाए हैं, अच्छा, he has also submitted that if the age of the defendant number 1, without prejudice to the aforesaid submissions, if the age of the defendant number 1 as disclosed in his evidence is taken as correct, then he was a minor even on the date of institution of the suit. Correct?
Yes, sir.
I take your words as correct.
Yes, sir. There is no necessity.
Issue notice to the respondents under speed post and ordinary process for which requisites be filed within a period of 1 week from today. Let the records be called for from the concerned court. Communication with full facts के करना है इसमें. Office to tracks speed post together.
In the degree, date of institution of suit and everything is given.
No, that's right. You must have calculated.
Okay.
We are posting it on 14th October.
Item 23, 2nd April 12 of 2021.
Only not
Refused. पिछली बार 2000 फाइन दिए थे.
only not
उसके पहले 1000 रुपए फाइन दिए थे. उसके पहले there is an order that no adjournment will be granted by you of last chance was done. Last chance 4 order में हो चुका है.
भैया this is not this way. He left the court and due to he felt uneasy. So it will be taken up tomorrow morning.
आपके हैं इस पे तो
We get only one cause is supplementary.
counsel for the applicant seeks adjournment on the ground that the arguing counsel Mr. B.V. Kumar is unwell and has left the field. क्या पता उनकी तबीयत कल कैसी रहे. Post this case on 2nd of January 26. ठीक है? तो 87 करते हैं. इतना पुराना केस में सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं बनाए हैं तो क्या ही कर रहे हैं आप. इसीलिए ये सब सब्स्टिट्यूशन फाइल होता है. पता कर लीजिए सब जीवित हैं कि नहीं.
1924, 2nd April 14 of 2021.
Yes.
So this, they were the originally the defendants minor.
So it was decreed or
Findings are
dismissed?
calculated and also both times it was decreed and then later upheld.
So what is there? Nothing.
And in this, although this it was filed for permanent and remission manner, but the title and everything has been decided, my lord. Order to simply sign for the decree of permanent mandatory injunction just to restrain the defendant and his men.
What was the nature of dispute with regards to the title? What was the nature of dispute?
Well, the nature of dispute was that this defendant's claim was that he was the grandson of one lady who was the daughter of this person, one Suraj Narayan Singh, from whom they had bought the traditional party.
They were claiming by virtue of said deed.
Yes, ma'am.
They were in possession.
Yes, ma'am.
Then
Well,
what is your title?
Our title is that in 1981, this lady named Puran Devi, who was also the daughter of this Suraj Narayan Singh, she started living there, and it is said that she claimed herself to be the daughter of that person. And she started living there, and her name was also there in the survey Khatiyan, my lord.
So,
And later, these petitioner party they filed an
you
objection.
see, they are in possession by virtue of a registered sin. Did you challenge that said deed? Then they have prima facie title over the property. They are in possession of the property. Incidentally, the court can certainly go into title. There is no complicated question of title involved in this case. Once there is a registered say deed, you have to challenge it and seek possession.
Yes, ma'am, that was not challenged myself.
So, you are the defendant, you never took any steps to challenge that deed.
Yes, ma'am, but these petitioners are claiming that portion of land by adverse possession, my lord.
No, is there any finding of adverse possession? No, they are claiming that property by virtue of a registered say deed.
No, my lord, later some portion of land.
Which portion? Or the learned counsel for the appellant. This appeal has been filed against the judgment dated 36/2020 with the bracket decree signed on 9/7/2020 that was passed by learned principal district judge Jharkhand in civil appeal number 69 of 2016. Whereby the first appeal has been dismissed and the judgment dated 16/9/2016 within bracket decree signed on 29/9/2016 passed in title suit number 216 of 2004 has been affirmed. The learned trial court had allowed the suit, had decreed the suit on contest under Order 8, Rule 10 of CPC. On contest without custody. If the learned trial could defeat the suit under Order 8 Rule 10 of CPC in view of the fact that there was neither any written statement from the side of the defendant nor any evidence was brought on record. The appellate court has dismissed the appeal and the defendant is the appellant before this court. The learned counsel for the appellant, while assailing the interim judgments, has submitted that in a case seeking permanent mandatory injunction, the court has entered into title dispute between the parties, has pronounced on title of the plaintiff. Yes. After hearing the learned counsel for the appellant, this court finds that the suit was filed seeking a decree of permanent mandatory injunction restraining the defendant, his men, agents and servants and labor etc. from harvesting the paddy crop grown by them over Schedule 3 land and thereby dispossessing them therefrom and so for any way disturbing their peaceful possession over land of CS Khata number 37 of Moza Bara Nagpur and for cost of the suit. The plaintiff claimed right, title and possession over the suit property It was their specific case that one Shushila Kumari Devi and Ambika Devi had purchased 2.39.5 acres and 3.20 acres of land respectively in different plots under Khata number 37 of Moza Baranakpur by registered sale deed dated 4/1/1945, 29/6/1946 and 23/1952 from the rightful owners for valuable consideration. Ambika Kumari Devi died in the year 1955 issue list, and after her death the land was inherited by her husband Rangnath Lal, who also died in the year 1957, and the property was inherited by his three nephews. Out of which two died in the 1949 and 1943. It was the further case of the plaintiffs that plaintiff number 1 and his brother within bracket, father of plaintiff number 2 and 3 purchased the entire land from the previously, which was purchased by ये पुराना ये staple asset क्या हुआ है तो ही नहीं था not able to read it. What is it? लिफ्टिंग निकालने वाला एक डिवाइस आता है ना, इससे नहीं, there is a separate device, उसको खरीदिए. The plaintiff number 1 and his brother, within bracket father of plaintiff number 2 and 3, purchased the entire land of 2.39 and a half acres, within bracket 2.39 and a half acres, which were purchased previously by Shushila Kumari Devi. And after death of the father of plaintiff number 2 and 3, in the year 1996, his share was inherited by his two sons, plaintiff number 2 and 3. It was further claim of the plaintiff that one, Jaldhar Singh had purchased 81 dismal of land in plot number 140 to 143, 214 and 215 out of their total area of 1.62 acres pertaining to Khata number 37 from Pancham Narayan Rai and Mathura Narayan Rai by virtue of registered sale deed dated 23/1952. See, Jaldhar Singh was living in Bhimbar and found it difficult to look after the land. And since he was well known to plaintiff number 1, he requested the plaintiff number 1 to look after his land. And the plaintiff number 1 continued in possession of the property since 1952. And Jaldhar Singh died unmarried in the year 1965, leaving no heir. And the plaintiff number 1 claimed that he has perfected his right, title and interest, being in possession of the suit property for more than 12 years. The property was, it was also asserted that the land was recorded in the name of Chandramohan Singh in CS Record of Rights, and after his death in the year 1930-32, his only legal heir was Suraj Narayan Singh. He also died issueless, and his wife deceased him. And he died sometimes in the year 1948-49, leaving no heir in his family. The plaintiff also stated that in the revision survey of land, Moza Badanaki started in the year 1981-82, when the land in question was recorded in the name of Puran Devi, to which plaintiff number 1 filed an objection under section 83 of the Tobacco Tenancy Act, which was numbered as objection number 3 of 86. and khata was ultimately opened in the name of Umesh Prasad Lal and others. That is plaintiff number 1. And ultimately, the finally published record of rights made on 14/7/1995, the new Khatian was distributed amongst the tenants and / riots in due course. And the land bearing cadastral survey plot number relating to the suit under CS Khata number 37, described in Schedule 1 of the plaint, were given new plot numbers described in Schedule 2, and they were recorded in RS Khata number 2 in the name of Akhileshwar Prasad Lal and Umesh Prasad Lal, sons of Churaman Lal, one share equal, and Mahesh Prasad, son of Bhagwan Lal, one share. The share shown was incorrect. As the property was exclusively belonging to the plaintiff number 1. And ultimately, a petition was filed under Section 87 of Tutanakil Tenancy Act for rectification of share. And suit number 864 of 95 was started. Ultimately, the finally the petition, the suit under Section 87 of CET Act. In another suit, suit number 1193 of 95 was decided in favor of the plaintiff, and the defendant's petition was dismissed. And the said order remained unchallenged and became final. The plaintiffs claimed right title, interest, and possession over the suit property. By referring to the order passed under Section 87 of the CMT Act, which had become final. The trial court records that the defendants appeared on 19/10/2004 but had not filed any written statement, so they were debarred from filing written statement, and the suit proceeded under Order 8 Room 10 by the order dated 28/5/2009. Thereafter, the defendants filed written statement, but same was not accepted by the order dated 18/1/2010. Although no issues were framed in absence of the written statement, but the learned court considered the points for consideration in paragraph 4, which are as under. The evidence was led from the side of the plaintiff, and by deciding point number 4, the learned court has taken the numerous materials on record and found that there was that the plaintiff unrebuttably proved that they were the rightful owners of the suit property. And ultimately, the suit was decreed, granting the relief as prayed for. The appellate court also considered the materials and found that and dismissed the appeal. This court is of the considered view that the learned trial court found the materials were placed on record by the plaintiff to come to a finding that the plaintiff was the rightful owner of the suit property. The learned trial court, while holding as aforesaid, has not committed any error, though the suit was only for injunction. This court is of the view that the claim of the plaintiff with respect to title remained unrebutted, and even while granting injunction, even while declaring the suit, the learned court has previously examined all the matters and thereafter granted the injunction. This court finds no substantial question of law involved in this case, which is accordingly dismissed. कल एक तो जजमेंट में एक जजमेंट कौन है इसका इंजंक्शन का एक तो केस में तो याद है वो जजमेंट है उसमें तो लगाना पड़ेगा इसमें ठीक है आई जस्ट साइट द जजमेंट
Orders from Daily Item 3, Secretary 318 of 2015.
Yes.
In this case, there are 4 IS. 2 IS for substitution of one is for appeal number 1 and another is for number 1. First one, IA number 11377/2005 for substitution of legal heirs of respondent number 1 whose name is Udo Devi. Double 1377. Who was died on 15th of December 2019 because delay is there because the Kalyam second appeal is twice dismissed for default and then after restored and during that period could not find the interrogatory of litigation, therefore delay is occurred.
So at the stage of restoration, notices were not issued?
No notice were issued. They have received the notice, but didn't turn up before this High Court to
who have received? You say that they expired in 2019.
19.
So when was the restoration? 2019. 13th when? So what do you want?
No, I want to substitute the legal heirs of respondent number 1 in this appeal.
And what about IA number 11380? There is also a delay.
0 for substitution of Supra, who's the appeal number 1.
देखिए first year लिखिए IA number 11377 of 2025. This petition has been filed seeking substitution of respondent number 1 who is said to have expired on 30/12/2019. इस पैराग्राफ में इनका लीगल ईयर्स
Explain from the para 4 to onward.
4 to onwards.
नहीं 4 to
किस पैराग्राफ नंबर बताइए?
हाँ पैराग्राफ में जो पैराग्राफ 12 में है
एक बार मैं पैराग्राफ भी नहीं बता पा रहे.
पैराग्राफ 12 में जो लिखा हुआ सर लीगल ईयर्स.
The learned counsel submits that the name of legal heirs and successors has been mentioned in paragraph number 12
Yes.
of the interlocutory application. Let notice be issued to the proposed legal heirs and successors of the respondent number 1.
Yes.
Respondent number 1. In ID number 111377 of 2025, for which requisites under ordinary process as well as registered cover as well as speed post be filed within a period of 1 week.
This is notice as per the order 3 rule 5 will be allowed to the summon to serve the counsel for the lawyer who is representing the execution case 3 of 19.
तो respondent number 1 को तो नहीं जाएगा ना?
नहीं उनके काउंसिल को चला जाएगा.
उनके काउंसिल को चला जाएगा. डिसीज आदमी के काउंसिल का क्या वैल्यू है? वहाँ सब्स्टिट्यूशन हो गया
एग्जीक्यूशन में हो गया और उनको हम क्या सीएमपी में रेस्टोरेशन में भी हम सब
आगे नंबर 11379 of 2025. The learned counsel for the applicant has prayed that the notice be served upon the respondents who are the decree holders through the counsel who is appearing for them in execution case number 3 of 2019,
Yes.
pending before the court of civil judge within bracket senior division clause number 2 of number 2 Gumla.
Yes.
He submits that the respondent number 1 has already been substituted in the execution proceedings. Correct?
Yes.
Considering the aforesaid submissions, let notice be issued in this second appeal.
Yes.
In this second appeal, इसमें substantial question और लॉ तो बना हुआ होगा.
ये admitted matter हम लोग coordinate bench has admitted this matter while issue certain questions law has been framed.
In the second appeal, through the counsel who is appearing for the respondents, who is said to be appearing for the respondents, and on behalf of decree holders in execution case number 3 of 2019, pending before the Court of Civil Judge Senior Division number 2, Gumla. The requisites for that purpose be filed by the appellant in the name of the respondents, present respondents, and also the proposed legal heirs and successors of respondent number 1.
Yes.
Within a period of 1 week, 2 weeks,
2 weeks.
within a period of 2 weeks from today. The affidavit regarding service of notice be filed within a period of 2 weeks thereafter, 3 weeks thereafter.
3 weeks I will file within 3 weeks. Later, after 1 week I will file this.
Within a period of 1 week thereafter,
Yes.
2 weeks thereafter.
Yes.
छुट्टी भी हो जाएगा ना?
ठीक है.
Within a period of 2 weeks thereafter.
Yes.
Post on 2nd December.
Yes, ma'am.
और भी कोई आइए है?
One more item, 11380 for substitution of appeal number 1, who is my elder brother. And also file of
There is a delay also.
Yes, there is a delay.
अभी सबको आने दीजिए तभी ना, सबको आने दीजिए, ऐसे डिले बिना सुने कैसे कंट्रोल करें?
So tomorrow is the date, and they have submitted a money for post of Naje, which was accepted, and police force has
We can't do
also.
anything. आपका इतना डिले है, बिना सुने कैसे हम इसको आपका सब्स्टिट्यूशन करें?
Till the appearance of status was held.
क्या? There is an order.
There is no order, because I have filed a stay application 6525/2022 for a staying notice admitted matter till the appearance of decree holder. Admitted matter.
आप किनकी तरफ से?
DC state.
वहाँ पे सब्स्टिट्यूशन हो गया?
हाँ सब्स्टिट्यूशन हो गया।
इनका भी?
हाँ इनका भी हो गया। एग्जीक्यूशन केस में स्टे हो गया है और रिस्पॉन्ड नंबर 1
comes for the IA number 6525 of 2022. The learned counsel for the appellant has submitted that the petition has been filed seeking stay of further proceedings in execution case number 3 of 2019. He submits that क्या stage है?
For giving the delivery of possession to the decree.
The learned counsel has submitted that the suit is, the execution is advanced stage, is in the advanced stage, and writ for delivery of possession has already been issued. ये क्या आपका टाइटल सूट है क्या है?
The plaintiff decree holder has filed a title suit before the court, which was dismissed on the ground of this suit, and thereafter filed an appeal. Appeal has been held, so judgment of reversal is made.
Considering the aforesaid submissions, further proceedings in the execution case shall remain stayed till कौन सा डेट रखे हैं इसका? कौन सा डेट दिया है इसका? Till 2nd of December. कौन सा आइए? आइए पेंडिंग है।
Item 472 of 2017.
What on 587? The delay of 45 days
In filing that second appeal.
delay of 45 days. No notices has been issued.
SA number 432 of 2017. DIE number 11587 of 25. The counsel for the appellant has submitted that the petition has been filed for combination of delay of 45 days in filing this appeal. Issue notice to the respondents on the interlocutory application under 2 speed post for which recusals be filed within a period of 1 week. Speed post and ordinary process. Post this case on October 7th. Office to track speed post.
Item 572 is 119 of 2022. Misuse.
In this case, the pursuant to the order dated 23rd June 2025, the notices were sent by Gosti Kovar upon the response number 6 and 7. Now we have already filed the supplementary with regard to them. But so far response number 8 is concerned, Poonam Devi. It has been reported that she died. So died, therefore, an application has to be filed for substitution of response number 8.
SA number 119 of 2022.
And response number 1 to 5 who are the contesting, notices have already been served through court, but they have not appeared.
The learned counsel for the appellant has submitted that supplementary affidavit regarding personal service of notice to respond number 6 and 7 has been filed.
They have refused to accept it.
And
The lawyer appearing on their behalf
he submits that the lawyer appearing on their behalf has refused to accept the notice. He submits that the notice
upon the response 1 to 5 have already been served.
upon respondent number 6 to 7 be accepted as valid by way of refusal. Considering the submissions, the notice upon respondent number 6 and 7 is accepted as valid. With respect to respondent number 8, he submits that she has expired.
She
has expired. Accordingly, the learned counsel prays for time.
1 with 10 file substitution.
Prays for 1 week time. Post on next Thursday.
Item 6 for statement 166 of 2022.
Who is the applicant? Who is the applicant? Appellant absent. Post on 15 December.
Item number 12 below, and that the notice was issued at admitted matter below, first appeal, and the notice was issued to respondent number 1 and 2. Below 1 has been received by the employee of the company, and 2 has been validly service. So now the employee has been received, it will be treated as a valid service.
12 colloquy 1.
नहीं हम वैसे हम रिक्वेस्ट
Public.